MSP, thank you very much indeed. It's drive time. And the Lord Advocate signalled a change in the way Scotland's judiciary will prosecute certain offences. It will mean there are changes to corroboration. Now, in a statement issued this afternoon, the Lord Advocate, Dorothy Bain, KC, says, in quotes, it could transform the way we prosecute all offences, in particular sexual offences. Rape Crisis Scotland are saying this is hugely significant. Now, Thomas Ross, KC, is a former president of the Scottish Bar Association. He joins me now. Thomas Ross, hello.
Hi, John.
Your reaction to this?
Well, I agree. It's absolutely transformational. You know, it will undoubtedly result in thousands of cases which couldn't have been prosecuted yesterday now being taken up for prosecution. I think that's where we'll see the biggest difference. Just explain
what this corroboration, what was that used for?
Yeah, well, it took the judges 126 pages of A4 to explain it, so I'll do my best, John. But basically, the important things which require to be proved by two witnesses in a criminal case are firstly that the crime happened, and secondly that the accused committed the crime. In rape cases, Scotland had a peculiarity where penetration, which is obviously an essential of rape, had to be proved by corroborated evidence. And the debate really was what amounts to corroboration. So obviously if the female was saying that she had been raped and the accused admitted that he did sex with her but was arguing that it was consensual, then you would have two sources. Equally, forensic evidence could provide the second source if there was evidence of some transfer. But those two examples apart, so in other words, where the accused didn't admit intercourse and there was no forensic evidence, as a general rule, other cases were not prosecuted because they didn't have two sources of evidence to prove that there was penetration. As a result of this decision, it's said that distress on the part of the person making the complaint observed by a second person can corroborate her account of being raped by the perpetrator.
What do you make of this, Thomas? Because Rape Crisis Scotland are saying that most rape cases never make it to court. In many cases, this is because of this requirement in Scotland for corroboration. So you believe this will see the number of cases coming forward to prosecution to court increasing and the number of convictions for rape increasing?
No, I don't think it'll increase the number of convictions for rape. I don't think that, because obviously at the moment all the cases that come to court have at least two sources of evidence, and what the court has said is that cases can now come to court with less evidence than they had before current times. So logic would suggest that if they bring cases with less evidence, it will result in less convictions. In a percentage way, however, they will bring many, many more cases. So there will, in numerical terms, I suppose, be many more convictions. But I don't think that it will increase the conviction rate, if I can put it that way.
Do you think it's a good thing?
Well, if you'd asked me 5 years ago, I probably would have said no. But I've spoken to some people who have made complaints, people who have believed 100%, whose cases were not taken up. And, you know, that so I think possibly I can understand why things have taken this course. It's very new in terms of the decision was only announced today. Everybody in the law knew that it was going to happen. I can see that it is a bad thing that somebody who makes a genuine complaint is told that the case can't be taken forward. Equally, there are risks on the other side. But on balance, I think probably it is a good thing.
You and I have talked, and you've talked a lot on Radio Scotland about this before, and how the complexity of rape cases and the low conviction rate when it comes to rape cases. We've now got this corroboration element being taken away. Do you think there will be further changes? We know there are pilots coming, aren't there, to do with not having juries?
Well, I don't think that'll ever happen, John. You know, the strength of opinion against taking away a citizen's protection in the form of a jury is so strong that I just don't think it'll ever happen. Of course, the SNP have got the numbers. If they want to make it happen and drive it through against the weight of opinion of those people who conduct trials, I don't suppose anybody can stop them. But it seems such an extreme position to take where previous people who have done it, are essentially dictators who don't want members of the public to play a role in determining the guilt or innocence of citizens. I mean, so I think the weight of opinion against removing juries is so strong that I'm hoping that the SNP will see sense on it. But, there's no evidence of it. They seem to be doubling down on it when they spoke in the Parliament a few weeks ago. I'm just possibly being over optimistic.
OK, Thomas Ross Casey, former president of the Scottish Bar Association, thank you very much indeed. It's Drive Time. Now, we don't have any